Good morning, Judge. So I have emailed the defendant and they have not yet responded to the email, and I also tried to call them, but their phones were switched off.
Right. Have you had trouble with contacting them in the past?
I believe the claimant's counsel was just saying that they were also having difficulties contacting them. Could you please confirm?
Yes, that is correct, my lord. We have made attempts in order to agree certain documents for today's bundle, and despite numerous emails, several emails on the same matter, we've got no response whatsoever.
Right.
Using same email addresses that have previously been used successfully.
That's to the defendant's law firm, is it? Or to them?
My lord, previously they have used both a law firm and counsel, as well as their own representatives. So we have always included all of those in all email correspondence. Approximately 3 weeks ago, we had a response from those who were legally representing them, not counsel.
Yep.
And in response to our email, we had an email back saying, please do not correspond with us any further on this matter. We replied to that email asking whether or not they'd notified the court they were no longer on record, and whether they had satisfied all the legal requirements in order to do that. And we got no response to that email, and we've had nothing thereafter.
I see. I think it would be helpful, quite apart from anything else, if you could lodge that relevant part of that correspondence, provided there's nothing privileged in it, with the court. Are you happy with that, Maita? That they lodge the email exchange or lack of exchange with the court?
Yes, so if they can just send it by email and I'll forward it to you, Judge.
Well, we want it on the court files so that so that everyone knows that what attempts have been made to contact the other side. Very well. I think that what we do is if we can record the fact that the attempts have been made to contact, we delayed the start and have attempted to be in touch with the defendants and their legal representatives, then we should probably just begin and maybe at the end of any order we make, give liberty to apply if there's any particular point that, if there's any explanation for not having attended.
Yes, Judge, certainly. So I'll add it on the court's record that we've tried. Yeah. Yes, Judge. So I would like to begin by reading our statement.
Yes, of course.
Yes. The pre-trial review is being held by way of video conference. Any orders or directions made or issued by the registry will be issued by the registry on Justice Lord Angus Glennie's instructions. We are here for a pre-trial review in the matter of CFI-071-2020 before Justice Lord Angus Glennie. The claimants are represented by Global Advocacy and Legal Counsel. Lead counsel is Lewis Wright. The defendant is not present.
Yes, thank you. Yes, Ms. Wright.
My lord, hopefully you have had access to the bundle which was lodged earlier this morning.
Which bundle is that we're talking about? I've received the... Sorry, was it lodged this morning?
It was, yes. We did invite the court for access. Hopefully that has been successful.
I've got the case management documents and the statements of case, but not any separate bundle.
My lord, we did grant the registry access through case lines. It may be that we offer our apologies on that because it was delayed in proceeding, more delayed than it usually would be, for reasons that we were waiting for the defendant's counsel to agree to certain documents before uploading. They have since been uploaded, but we've made it clear that they are the claimant's document and not agreed documents. But nevertheless, those are the reasons for the delay this morning. Our apologies.
Right. Do you want me to, probably no point in adjourning so I can look at them and come back, or is there anything you want to draw my attention to?
My Lord, there's nothing in there specifically. There's nothing controversial that I need to bring to your attention this morning. Certainly from the claimant's perspective, we are trial ready. We have uploaded also and filed the pre-trial review form, which indicates that we are trial ready. The claimants believe that the trial won't take anything longer than 6 hours.
Yep.
There is just one witness for the claimant that we shall be calling.
Mm-hmm. That's Mr. Al Zarouni, is it?
That's correct, my Lord.
And have you lodged a witness statement for him?
There are two witness statements, the first witness statement and Mr. Jaffar Al Zarouni's reply in evidence to the defendant's first witness statement.
Right. I haven't got the witness statements because I think they'll be in the bundles that you've lodged today. Are you proposing to lodge the defendant's witness statement yourselves, or are you going to leave it for them to lodge if they take part?
Well, we certainly have lodged it to date, depending, of course, whether or not they continue to, whether they engage further, perhaps will be a decision we take following today's hearing.
Yes. Very well. Mr. Jaffar Al Zarouni is going to give evidence by video link, is that right?
We are waiting to be guided on the court with that. My Lord, he would have, of course, in usual circumstances, been prepared to present himself to the court. However, given that we are still conducting hearings remotely, we have advised him that the possibility is he will give his evidence by video link.
Yes, I think that's almost inevitable. It will have to be that way.
Yes, my Lord, he's prepared for that.
Yeah. So some order ought to be made allowing him to give evidence in that way. Later, perhaps that can be added to the directions that are given.
Yes, Judge.
One thing that occurred to me on reading the papers is on the question of damages. You have a rather broadly expressed claim, and in the defence they say, well, you haven't given much particulars of it, which has some force. Do your witness statements go into that in some detail or not?
My Lord, we do recognise that, and it is something that we hope to put forward or explain in further detail through the skeleton arguments. The second witness statement, I believe, will assist further and go into more detail with regards to the damages.
Yes, but you haven't expanded your pleadings on that point.
No. My Lord, with the court's permission, we could amend the particulars if my Lord is perhaps...
I'm concerned that if you get to your case on damages only being set out in your skeleton argument, it gives only a few days for the defendant to discover for the first time and then deal with how you're putting your case. Seems to me that it would be useful if you would set out your damages claim in some either an amendment to the pleadings or as an additional particulars of the damages claim in some way that it sets out at least all the facts you intend to rely upon and broadly how you calculate the claim.
My Lord, thank you for that indication. Following from that, then, can we invite the court to direct the claimants to amend their particulars on that point? And yes, we could do that within 7 days.
Yes, very well. The hearing is when it's in June or what?
The 9th of June.
9th of June. There's now, yes, if you can do that within 7 days and to serve it, I think in the circumstances, make sure it's served to the 3 addresses you have for the defendant and his two separate legal advisors.
My lord, so you advise to send it to the firm that have told us not to correspond with them any further?
Unless they've come off the record in some formal way, they remain on the record.
I have checked the court file on that, my lord, and it appears that they haven't formally come on record, and it seems to be showing that the defendant is a litigant in person. Having checked the court record myself, it may well be that registry are able to update us on that.
Martha, are you able to help that?
Yes, Judge. So I have looked into the CMS, and I've noticed that in the defendants section, it shows that the defendant is the litigant in person, so they don't have any law firm on record.
Right.
Yeah.
Then I think you should therefore only serve it on the defendant in person.
I'm grateful, my lord.
There's no one else who can properly be served, I think. So we'll make an order then that you serve amended particulars of your damages claim within 7 days of today, and to serve it on the defendant personally at the email address that you've got for him.
Yes, my lord.
Is there anything else that needs to be done before the hearing itself?
Certainly not from the claimant's perspective, my lord.
How many? The defendants lodged one witness statement, you say?
Yes, just one.
Right, and who is that from?
Mr. Naeem. My lord, if you would allow me one moment to check the correct surname. Mr. Naeem Ahmed.
Yeah, he's an officer of Eastlift, is he?
He is.
Yes. Very well. And there's no other documents you need to recover or get anyone to lodge? You've lodged everything you think is relevant.
We have. At this stage, there's been no reply statement from or reply in evidence from the defendants, and at this stage, there's nothing further we require.
Very well. Maita, is there anything else that we need to cover for today's hearing?
No, Judge.
No. Very well. We'll limit what we say then to these matters. Going back to the previous one where we suggested you notify all three parties, the defendant and the two legal advisors. I think although it's useful to have that on the record from now on, if the defendant is registered as a party litigant, then there's no need to serve anyone else other than the defendant. What is the position, in fact, so I ought to know this, but I'm not familiar with this aspect of DIFC practice. Eastlift Dmcc is a corporate entity? Is that right?
My lord, yes.
Can a company appear in person?
No, my lord.
So
so they would need to
have they? When did they change their status from being represented to being?
My lord, I'm just trying to check. Apologies. Forgive me for staring at the screen. That's what I'm trying to check. Apologies, my lord. As is always the case, you can never find what you're looking for when you need it.
I see the defence was signed by lawyers. Was it drafted by lawyers?
There has been a lot of communication. It was drafted by lawyers, and there has been a lot of communication from NM lawyers, as well as Mr. Harris Bohr as counsel. We've not had any further communication from Mr. Harris Bohr since approximately. Harris Bohr is counsel. He communicated with regards to the filing of documents prior to the preliminary hearing. There doesn't seem to be any further communication with Mr. Bohr since January, and the email from NM lawyers advising us that they are no longer on record is dated just the 21st of April, so
right,
approximately 2 weeks ago. We can forward that to the court immediately.
So so that's 2 weeks ago they ceased to be represented. In those circumstances, is there a formal procedure, like there is in some jurisdictions, for notifying the defendant that they are no longer represented and required to be represented? Again, Maita, can you help on that? Maita?
Sorry, Judge, I did not hear you earlier.
Is there a process by which, when a party to litigation ceases to be represented by the lawyers on a record, where the court writes to them and tells them they need to instruct other lawyers, or is it just left to parties to make applications as appropriate?
So usually if the law firm like by itself wants to cease to act on behalf of that client, then they would usually file a Part 23 application notice and an order needs to be issued. However, if a new law firm wants to come on record on behalf of a former law firm, then we have a form online called a change of legal representative. And the third scenario is that if the client would like the law firm to cease to act on behalf of them, then they would just send an email to the registry and we'll remove them from the record.
Right, what happens?
Yeah.
This sounds like there's been an email two weeks ago from the lawyers saying they no longer act in this case.
Yeah, so on that basis, I believe, which is why the registry has removed them from the record.
But if the company, the defendant company, is not allowed to represent itself, as Ms. Wright tells me, then
no. So usually, a company can be a litigant in person, so that they would need to authorize someone within that company to represent them.
Right, they can be a litigant in person, can they?
Yes, yeah, but they would need to represent someone, like and provide us with like an authorization letter, assigning like X, Y, and Z to represent them in the court proceedings.
And is that something the court does of its own initiative when you understand there to be no longer any legal representation?
No, so usually that's done like at the beginning of any case. Like if the court knows that they're a litigant in person, then we usually direct them to file an authorization letter. I think in this instance, because they already had a law firm and then they came off record, which is why we have not directed them to file an authorization letter.
But should there not be an authorization letter? Otherwise, how are decisions to be communicated to the court?
Yeah, so usually actually so it depends on the judge's direction. If so like in certain cases the judge would like to have like an authorization letter, so it's not a mandatory thing by the kept by the registry, so it depends on the judge like hearing that case.
I see.
Yeah.
I think probably in this case, although Ms. Wright, I don't know if you have any comments, but my feeling is that given the circumstances and how close we are to the trial, which is only just over a month away, we ought to notify them of the position that they're presently no longer represented and invite them to sign or submit an authorization letter.
Yes, I have no submissions other than those, my lord. I can't see another alternative at this stage.
Otherwise, there's the risk of uncertainty.
Yeah.
If no one on the defendant's side knows precisely what is meant to be happening.
No, my lord.
So, Marita, can you get a request sent out to the defendant, inviting them to submit an authorization letter if they want to do so?
Yes, Judge, certainly.
And if they don't do so, then presumably we just proceed on that without one.
Okay.
Thank you very much. Then unless there's anything else, I think the only orders we need to make are an order about, or the registry can make an order about the witness evidence being given by video link, and the order to amend the particulars of damage within 7 days, and then the direction that the court send a letter to the defendants, inviting them to submit I forget what it's called now, authorization. But apart from that, I don't think there's anything else we need to do, and we'll confirm the date of the 6th of June, was it?
The 9th of June.
9th of June, with a time estimate of no more than 1 day. I think you say 4 to 6 hours, but let's say no more than 1 day.
Yes, my lord.
Is there anything else then and simply reserve the costs of today, or make them cost in the cause?
It costs in the cause, my lord.
Yeah.
My lord, may I raise another matter that I should have addressed at the start of proceedings, but it came to our attention just today that in fact erroneously the defendant's name, well, it was incorrect on the first witness statement of Mr. Al Zarouni. My lord, I can share my screen if that would assist the court at this stage. If I'm able to do that, I'm unsure. But it's just the defendant's name that was incorrect in the heading on page 1 of the witness statement. What we did this morning, once that came to our attention, is we wrote to registry and we amended the anomaly using red line amendment and requested permission to use that version in the bundles moving forward from today.
What was the name that you had put in?
Expresso Telecom, so completely different, my lord. It is Eastlift Dmcc, and that has been amended.
And this was the first witness statement or the second?
The first.
And the other side's first witness statement, did that respond to it, or was it exchanged contemporaneously?
It didn't. Yes, it didn't respond at all to that. I believe it perhaps went amiss there also.
And has it been reserved as corrected?
It hasn't, since we noticed just prior to the hearing, in fact, my lord. So we have actually included them in the email to the court this morning. So they they have indirectly been served with the amended version, but we haven't requested their permission or requested their comments on our request prior to notifying the court.
I think what I'll do is I'll, as part of the order, I'll allow the heading in the first witness statement of Mr. Jaffar Al Zarouni to be amended to reflect the correct name of the defendants as indicated in red on the amended copy lodged with the court. But I will order you to order the claimant specifically to serve an amended copy on the defendant and pointing out the amendment and the reason for it.
Yes, we will do that immediately.
Just in case it was received and put to one side because it didn't seem relevant.
Yes, my lord.
Very well.
We will do that immediately.
Thank you.
Thank you.
Then, unless there's anything else, Maitha, which ought to be included in the order I make today, then is there anything I've left out?
I do not think so, Judge.
No, very well.
Yeah.
I'll make the order in those terms, and we'll meet again on the 9th of June. Thank you very much.
I'm grateful. Thank you, my lord.
Thank you.